I'm Dru Stevenson, and this is a brief introduction to my professional responsibility course. This is a required course at every law school in the country. We will study the rules that lawyers must follow when dealing with their clients, or with judges, or with other parties in litigation or legal transactions. The goal here is not to try to make you a good person. By the time you're in law school, I think your moral compass is already set and calibrated, and a 3-credit course is not going to change it. You will, though, have to pass the Multistate Professional Responsibility Exam, or MPRE, in order to be admitted to the bar. So we will cover everything that is tested on that exam. Some of the rules we will study are also tested on the regular bar exam. It is useful for lawyers to know what's expected of them, of course, in practice in terms of their interactions with their own clients or other lawyers and judges, and also what could trigger a lawyer losing their law license or facing other sanctions like disqualifications from a case. Now, I'm going to take a moment to explain the course materials that I will be using in my professional responsibility course. This course may be different from most of your other law school courses because we do not use a traditional casebook. We will not read cases every week like you do for other subjects. Instead, my course focuses on the model rules of professional conduct that are published by the American Bar Association. These are the rules that are tested on the MPRE. And as I said before, almost every state, including Texas, requires that law school graduates pass the MPRE before being licensed to practice. The MPRE is a multiple choice exam. It's all multiple choice. And I've taken the MPRE over and over again so I could get a sense of how the rules are tested and design my own test questions to look like MPRE questions. My goal is that when students eventually take the MPRE, the style of the questions and how they test individual rules should feel familiar. And when you're in practice as a lawyer, keep in mind that the ethics rules, let's say in Texas, mostly follow the ABA model rules verbatim. Now, along the way in the course, we will also talk about not only how the rules are tested, but how they work in practice with clients, with real clients and real lawyers. We'll talk about how the rules are enforced in practice by the state bar and the courts. And our discussion of the model rules will give us some occasions to talk about how law practice actually works and some of the difficulties that you might encounter when you're a lawyer. Now, I've arranged the course subjects in order of how heavily tested they are on the MPRE. So we will start the semester with the most heavily tested subject, which is conflicts of interest, and end with the least tested subjects. We will take our time at the beginning with the most important rules and save the least tested rules for the end of the semester when everything tends to be rushed. Now, for my course, there are 2 books of practice questions that are required. The first is the Glannon Guide for Professional Responsibility. It has practice multiple choice questions with explanations, detailed explanations of the answers and short chapter introductions. I'm the author, and I arranged the book in the order in which we cover the subjects in my course, which is, as I said, in order of how heavily tested the subjects are on the MPRE. So you can proceed through the Glannon Guide from beginning to end over the course of the semester. The other book is the 500 MPRE practice questions that I make available as a free PDF on my course website. And also, you can order an inexpensive print-on-demand copy from Amazon. This book does not have explanations for the questions, just a citation to the relevant rule and an answer key, so you can look up the rule if you get a question wrong. Probably the best idea is for students to use the Glannon Guide to learn the material initially, and then use the 500 practice question book to further test their knowledge. Now, between the 2 books, there's approximately 750 questions total. Your primary work outside of the lectures in this course should be doing practice questions. And if you're doing them all, it will take about the same amount of time as reading cases in a conventional law school course. You should also read through each of the model rules at least once, probably as we study a set of rules in a given course module. And this includes the ABA's official comment to the rule, which the MPRE actually treats as part of the rule. My exams include a lot of questions directly from the 2 books. Of course, I'm not going to tell you which ones, but most of the questions on your midterm and final, at least 70% or so, will come directly from the two books, about equal shares from each. So if you have really mastered the practice questions in both books for the modules being tested, you should be in good shape for the exams. The exams will also include a few questions you haven't seen before, but which are very similar to the questions in the two books. Now, in addition to the model rules, there are some other sources or materials that we will talk about from time to time as we go through the course. These are ABA formal ethics opinions, which clarify or define some terms in the rules, and the restatement of the law governing lawyers, which honestly usually just follows the model rules, but it covers a few additional topics like legal malpractice and attorney-client privilege. I will also explain or discuss a few Supreme Court decisions about legal ethics, which in some cases actually forced the ABA to change the rule. But you don't have to read the case itself. There's only a handful of U.S. Supreme Court cases in this area, and I'll tell you when we get to them what points about the case could show up in test questions on the MPRE or on my exam. So to summarize, most of your work in this course should be focused on the two books of practice questions and the lectures in which I'll explain the model rules and sort of unpack them. A few more comments about the course. This is one of only two courses that law schools are actually required to require. Schools have a lot of discretion about other courses to require, even the first-year law school courses. But every accredited law school must require this course for all students. This requirement came about because of Watergate, which was a big scandal with the president that occurred in the 1970s. And a lot of the co-conspirators or wrongdoers in Watergate were lawyers, and it created a public relations nightmare for the legal profession. So the American Bar Association suddenly announced that all law schools would have to require a course on legal ethics. We usually call it professional responsibility, though, because ethics is too strong a word for lawyers. I recognize that a lot of students are in this course sort of against their will because it's required, and I'll try to make it as bearable as possible and as useful as possible.